Out of
Lordship's
list.
leave, subject to your lordship's consideration. It is, I understand, Milords, there is a difficulty today.
No,
There's
you
a ma-
take your chance. Do it fast because
There's a
shortage
matter,
of time.
Milords, that your lordship's directed to be listed today. It is for disposal. Your lordship will recollect. It is a CIT appeal order dismissed on the ground of limitation, defying the Supreme Court order on limitation.
All right.
Fix
But
it.
it will be better for you. You'll fix the matter on the opening of the
Very well.
application.
Subject to your lordship's consideration.
On 23rd, this matter will be listed. 23rd of June.
Given the number, he'll.
I have given the memo.
Already.
Grateful.
Yes.
Item 1.
May I please? The revenue has come up with an appeal against the order by Annexure 1, page 12. The issue is here within the composite contract, levy of the service tax with on the composite contract, or after the inclusion of mining in the 65 of the service tax act will be applicable or not.
Yes. What is the observation? Come
Yes,
to
that is what will kindly see running page 28. The finding is the revenue has examined and treated it as a site formation service, but the tribunal held in view of the above ratio laid down by the apex court, service tax as site formation service could be levied if there is a service contract simpliciter to that effect. However, once the contract is composite contract for the entire activities for site formation to segregate of ores, then the same has to be charged as a separate service that is called mining service, which made chargeable to servicer with effect 8/6/2007 only. Such operation under the composite contract cannot be treated as site formation or cargo handling service before 8/6/2007. But to clarify this, the CBSE by the circular clarified that if there is a composite contract, then the issue which has been dealing by the service provider has to tax on the actual service. Therefore, you also see the paragraph. It has been referring the paragraph internal 18, the scope of the contract, because all these the issues of service had to arise out of a contract. If this contract specifies the detailing of service step by step, that should be taxed as per the specific column and specific legislation as per the Act 65 and later on 105 later on. Therefore, the revenue has formed the question of law. If you also see page 9 of the appeal memo, whether on the fact and circum the case the tribunal justified to include the site formation clearance, excavation and earth moving and demolition service and cargo handling service within the meaning of service, ignoring the term of the contract. Suppose there is a contract, if the company one by one has been decided whether it should come under the purview of the mining service or not. If it is not come within mining service, then the respondent not liable to pay the service.
I think only question number 2 is material. Others are
yes, not.
Only question number 2.
Question number 2, yes.
Arts Mr. T.K. Satapathy, Senior Standing Counsel. Yes, this is
now GST and Central Tax.
GST and Central Tax appearing for the appellant. So this is an appeal under Section 35G of the Central Excise Act 1944 against the judgment dated 15/9/2000. It is judgment is 15/9. The impugned judgment?
Judgment date of hearing 9/8/16 and decision of 15/9/2016. Like page 13, last line.
So there is no delay?
No, no delay.
Oh,
within time.
Such a long time it is being taken up by the court.
Yeah, only the IA has been taken up, thereafter it's not listed. It was IA disposed of since long. 9/10/2017.
2016. Delivered in appeal number ST/10/12 by the customs Excise and Service Tax Appellate Tribunal, Kolkata Eastern Zone, Bench, Kolkata. According to Mr. Satapathy, by treating the entire works as the composite mining work, the Sistat has committed a serious illegality. Stop. This made this appeal on the following substantial question of law. Following question of law, court, just subpara, whether on the facts and circumstances of the case, the Sistat is justified to treat the whole service as a mining service which is chargeable to service tax with effect from 1/6/2007, and therefore the site formation, clearance, excavation, earth moving and demolition service and cargo handle service were not eligible to service tax before that date. Stop issue notice is made, which is returnable on July 21st. 24th of July 2023. Steps for service on the respondent shall be taken by 19th of May 2023 by registered post with AD. All right. Now this application has to be allowed. They have not pointed out this. This Miss 5/2017. You have not filed the certified copy according
That has been dispensed with.
dispensed to
Yes, order dated,
okay.
order dated, my lord,
All right, then we have passed the order.
Item 3.
May I please, your lords? Here is the matter. It is the second round of litigation before this honorable court. And in the first round litigation before this honorable court, this court has directed to whatever action they will take as per the Ashish Agarwal case. Thereafter, the issue notice under section 148 of the Act under annexure 2. The lordship can have to glance that page 16. It has issued on 25/7/2022. As
Yes,
for the provision on, as per annexure 1, I have quoted the provisions. If it is more than 3 years, it has to be give sanction by the principal chief commissioner. So here is the giving commission by principal CIT page 17. Well, principal CCIT.
yes.
That is the whole case. There is sanction should be given by the principal chief commissioner income tax instead of principal commissioner income tax.
Is there any notification?
Well, we have already mentioned in my reply when the 148 AB notice has been issued to me. I have also.
No, but you have referred to any notification because this is actually the power of delegation. Who will sanction this from the state? It goes to the certain authority.
As per the amendment provision of 148 section, my lord, as per new scheme, this is the provisions as has been,
Where is that provision? I am asking you to show me that provision.
that is annexure 1. Extract portion section 151,
Annexure?
annexure 1, page 14. Section 151, sanction for issue of notice as substituted by the Finance Act 2021, madam. Specified authority for the purpose of section 148 and section 140 shall be principal commissioner or principal director or commissioner or director if 3 years or less than 3 years. Here is the case, it is more than 3 years.
Who issued the notice in your case?
Notice issued by the principal commissioner. That is page 17. That is last line. This notice is being issued after obtaining the prior approval from the principal CIT Sambalpur. It should be principal CCIT from Bhubaneswar. It cannot be principal
Where is
CIT.
that? Where is that that he issues? Who had given this sanction?
That is page 17, last paragraph 3. Page 17, paragraph 3. The notice is being issued after obtaining the prior approval of the Principal Commission Income Tax Sambalpur accorded on dated 18/7/2022. It is beyond the 3 years period. Had it been within the 3 years, it is correct. When it is more than 3 years, it should be given by the Principal Chief Commissioner of Income Tax, not by the Principal CIT. So that provision is very much clear, section 151 to that extent.
So your matter is beyond 3 years.
Beyond 3 years, because it's 18-19, year ending by 31/19, so it is beyond 3 years. And by the way, we have also given reply to the authority when passing the order 148 AD, that is annexure 8, page 36, third paragraph. Thus, the notice in question are established to be without jurisdiction, competency and authority for the same having not been issued by the approval or competent
Alright.
authority.
Already you'll examine on the limit.
My lord, in this case, lordship kindly see the order annexure 6, page 26, that is 148 AD order is under challenge, my lord. That is the order, my lord, that is before.
No, he has raised a question, the notice issued by a person who has no competence.
My lord, that has already been dealt with by that order. And also the subsequent order of this honorable court in the batch of cases, my lord, yesterday my lord senior was
Yes.
submitting, that is in Kailas Kedia's case, my lord, there the honorable this honorable court held that all the issues will be raised at the before the at the time of 148 proceeding, my lord.
Yes.
So, my lord, this is open for the petitioner to raise all this because 148 in batch of cases, 148 AD order was not entertained by this honorable court with the ground that, my lord, that is that whatever grounds are there, all issues were
No, just wait.
directed-
No, just wait. That's all right. This is an alternative
Yes.
view. It's also valid.
Yes.
That the this avenue has been kept open for the SSC to raise all the questions. But question is here the
question is,
precisely.
my lord, here I find, my lord, what I
Yes.
came to know, my lord, that is the earlier notification in view of Ashish Agarwal's case, my lord, the honorable appeals court held whatever question was there earlier, my lord, that will be continued with the
By the
issuance of
earlier
notice
system.
and all this, my lord. That will be subsequent to the whatever position were there approval by the principal
You
commissioner.
file
or-
a short affidavit.
I'll
You
file.
file a short affidavit.
I'll file.
Heard Mr. J. Patnaik and J.M. Patnaik and counsel appearing for the petition. By means of this petition, petitioner has challenged the competence of the issuing authority of the notice under section 148A,
148.
148 dated 25/7/2022 according to Mr. Patnaik, in view of the delegation of power of issuance of notices, particularly when the notice is issued after a period of 3 years, the principal commissioner IT doesn't have any authority to issue such notice. The persons who can issue such notice have been well defined, as it be evident from Annexure 1 to the petition. Issue notice returnable on 6th of July.
My lord.
Stop. Since Mr. S.S. Mahapatra on it.
And no further steps.
Yes, no further step, because he's
No
appearing.
further steps, because in this case that
No, no, my lord,
they are giving notice, if you are not getting order from
Just
the court.
let me complete the order first, Mr. I have not completed the order. Standing Council, IT has appeared in web notice for the opposite parties, no formal notice is called for. The memo of appearance filed by Mr. Mahapatra and its Senior Standing Council is taken on record. Stop. And no formal notice, eh? Stop. What is the prayer in this IA?
IA, my lord, that is, lordship kindly have a glance. Page 26, the notice of July 2022, my lord.
All right, let us,
They-
we have fixed a
The
very short
proceeding may
date.
continue, my lord.
Not
That
take
will
any
be subject to
coercive
result of the case. That,
Not to take any coercive action.
no, that may be
because they
subject
have
to result of the case,
They have
whatever.
to pass order under section 148 after 148 AD, madam.
All right, whatever will pass on the next date, not today, because it was taken, notice was issued long back.
Yes.
All
When
right,
it is 18/6/2022 and not what is long
No.
back,
The notice under challenge is July
Notice of-
2022, my lord.
22.
Yes.
what are you saying there? What is the date of the notice?
Date of the notice. my
27th
lord,
May 2022,
1 year
lordship
back.
kindly have a glance.
022.
So it is not long back according to you.
Yeah.
Mr. Patnaik, when making
Ma-
a submission before the court, be
Ma-
careful
ma-
about your words.
My lord, we have, as per the notice, we have already been submitted, whatever we have submitted before the authority. There is no jurisdiction to pass.
We are not
on-
passing any interim order in view of this, the period that already have elapsed after issuance of the notice. We have not also disposing your interlocutory application. You can mention it at any point of time. Yes, call the next matter.
Item 5.
My lord, interim prayer will not to take an action.
Dismiss IA.
No, they have already issued notice to that extent. If you not get any order from the court, we have to proceed. They already issued notice.
That you have not placed before us.
That is now present, they have issued.
Now,
notice.
after the order is passed, you are placing.
No.
Is it the way to
My
conduct in a
lord, my
court?
lord, they have issued notice on letter 15/5/2023, my lord, saying that if you not get an order from the court, we have to complete your assessment.
Did you place this order before us in the record so that we can see this order?
I am going to placing, my lord.
Now,
May
this
I
is the
excuse
way
me?
to place in a writ petition a paper. You take it from your packet and place it.
I may be excused, my lord.
It
because
is
this
related
is the-
application,
this is the
lordship kindly
notice.
have a glance to prayer. No, keep it. Lordship kindly have a glance to prayer. Prayer, my lord, the 148 order, 148 AD order, which is under challenge, that is of 27th May 2022, my lord.
No, that is
Had
why I'm pointing
yes,
out, yes.
Had it been there, if any subsequent order has been passed, that must have been assailed in this case, my lord. Unless that has been.
SL at least placed in this record. You should place in the record. This is imminent danger. You are to demonstrate before the court, not to court to find out from records.
I received it on 15th May 2023, madam.
I don't.
2 days back, I received it. On 15th May, my lord.
As
They
if
said
you are.
that if you not get an order from the court, we have to proceed and pass the order. This is the notice they have issued to us.
You should have filed it with an affidavit. I'm issuing notice in the interlocutory application, Mr. Mahapatra. Heard Mr. Sajin Search, appearing for the applicant IAO 6809 of 2023. This is an application for staying the further proceeding on the basis of the impugn notice dated 25/7/2022 as issued under section 148 of the IT Act 1961. So Mr. James Patnaik Learned Council, Mr. Patnaik Learned Council has submitted that. Give the copy of this notice and show and give a copy also to Mr. Mahapatra. Mr. Pat- Have you gone through, I think, a prima facie case they have petitioner has established?
Yes.
Let
the
us,
notices-
let us examine it. We are fixing the matter on 24th of July. In the
Yes.
meanwhile, you file the counter affidavit.
Yes, my lord, yes.
All right. But Mr. G.
Extra
Sahu-
copy thank you.
Oh, sure.
Extra copy
sure.
I will give.
Learned Senior Counsel listed by MSK Sahu, Learned Counsel for the petitioner. By means of this petitioner has challenged the notice is issued under
I
section.
have
one-
challenged Annexure 3, 148
Yes,
D belongs.
the order under 48D.
Sorry,
Course,
sorry,
yes.
yes.
Challenged under, challenge the order dated 31/3/2023,
3 and 4.
annexure 148, under order, under section 148A within brackets small a of the IT Act. Annexure 3 to the writ petition. 4 also you have.
4 also, yes. Because that's
And
consequential
also the
notice.
notice dated 31/3/2023 under section 148 of the IT Act, annexure 4 to the writ petition. Stop. Along with that, the petitioner has also challenged the notice that has been issued under section 148A within bracket B, notice dated 24/2/2023 and 28/2/2023. Annexure 1 to the writ petition. That is also you have challenged. Stop. According
Yes,
to
1, 3 and
according
4.
to Mr. Sahu, the petitioner is entitled to get the exemption under section 10 within bracket 23C of the IT Act. Stop. If such exemption is considered, the entire exercise will be of no meaning. Stop. Issue notice returnable on 24/7/2023. Since Mr. R.S. Chimankal under Senior Standing Counsel, IT Department, has appeared in which appears in which notice for the revenue, no formal notice is called for, but the petitioner shall supply how many additional copies? 2 additional copies.
Yes, my lord, 2 at copy.
2 additional copies to Mr. Chimankal and counsel by tomorrow. Stop. Now, I heard Sajin's and also Mr. Aris Chimankal's Sajin's. This is an application for staying the further proceeding in terms of the notice as issued under section 148 of the IT Act, annexure 4 to the writ petition. till disposal of the writ petition. So we have issued notice for consideration of the challenge of the petitioner as set out in the writ petition. Stop. Issue notice returnable on such and such date, since Mr. Aris Chimankal and such and such appears in his notice for the opposite party. Revenue, no formal notice is called for. Stop. Notice is made returnable on the same date. Meanwhile, the revenue may file their objection, if any. Meanwhile, the proceeding in terms of the notice under section 148 of the Income Tax Act, within bracket annexure 4 to the writ petition, shall remain suspended. So,
Item 6.
urgent certified copies.
Your Lordship, directed stay of further proceeding, my Lords.
Proceeding in terms of 148 is state, suspended, not state.
Deeply obliged.
Item 6.
Here, in this case, I am challenging validity of Rule 4 of the Odisha Group C, B, repeal and special provision Rule 22. In similar matter, your Lordship has already.
There are other matters of pending.
Yes, my Lord.
When the date is fixed, just tell us.
22nd June.
All right, give the order. So we are fixing this matter also on 22nd of June. Just in para 6, make a change. Mr. H. M. Dhal, Additional Government Advocate appears in his notice in place of Mr. D. Naik. And the same order, returnable date is same. All
10, 11 and 12. Similar matter.
similar matter?
Yes, my Lord.
Mr. N.C. Raut for the petitioner in both the matter. 11 and 12. And 10,
11 and 12.
not 10.
Yes, my Lord. 10, 11 and 12.
All right. So this is similar order.
There are other matters also, Your Lordship, 15 and 19. 15 and 19, Your Lordship, same matter.
16.
15, 15 and 19, Your Lordship.
In the meanwhile, just remove the defects. There are defects identified
Yes,
with the
sir.
list. In the meanwhile, the defects shall be removed. Yes, 15, Mr. J. Biswal, petitioner, similar order, 22nd June.
My Lordship.
Mr. Dhal is appearing. This, you are also challenging the rule 4.
Yes, Your Lordship.
You are appearing, Mr. Naik, in this matter.
My Lord, I am
Not Mr. D. Naik. Not Dhal.
I am appearing in 6, 10, 11 and 12.
All right, 11 and 12.
10, 11 and 12.
Already first matter, Mr. Raut's matter, Mr. Dhal is appearing. J. Biswal in 15 and D. Naik for the state. And then 19. Mr. Biswal, 19.
19 for, yeah, on behalf of Mr. M.K. Sahu, Your Lordship.
Oh, you are not there on record.
He was there, Your Lordship, but he had some matter fixed up, so he has to.
All right, Mr. J. Biswal, for the, on instruction of Mr. M.K. Saul and counsel for the petition and.
And my lord, 7, 8 and 9, my lord. 7, 8, 9 and 17, 18.
Just wait. The defects,
I will intimate Mr. Sahu in 19 days some defects. He will remove it accordingly. Your
by the
Lordship.
next date.
My Lordship. In 15 days, no
What
defects.
is your matters?
My lord, 7, 8, 9, 17 and 18.
7, 8, 9. You are Mr. K.K. Swine.
On behalf of KK Swami, my lord, K. Swine.
No, just you are there, K. Swine only, 7, 8, 9, K. Swine. And who is Mr. Naik? You are for the state?
My Lord.
Mr. D. Naik for the state. And then after
7, 8, 9 and 17, 18.
17 and 18. Okay. You are also there in 17.
My lord.
18. Okay. All the matters are 22nd.
Yes, my lord.
can I seek a lordship's indulgence, your lordship? There are other fresh matters which are not on board today, but the same issue is involved. Can I pray that the notice also be issued? But I've heard that tomorrow and on 18th there is no court, your lordship.
No, there will be other,
I am just giving a memo, your lordship, of the
you
number.
just file a memo, all the matters will be listed on that day. Just inform that all the matters, this other matter, fresh matters not on board.
My lordship.
You give a memo that will be listed on 22nd,
Yes, sir.
along with those matters.
My lordship.
And Mr. Naik, that you have received the notice, just to give a copy of your memo to Mr.
My
Naik,
lordship.
so that he can also prepare for these things also.
My lordship.
The counter will, one counter and. because
All
the
right,
issue
you
is the same,
prepare
we'll
the
have
counter,
My lord.
because we'll issue only notice and then take up the matter.
I'm grateful.
Yes.
Grateful, my lord.
Next.
Item 13,
Yes, Mr. Acharya.
may it please, my lords. My lords, this is an petition challenging the order under section 148A(d) and the consequent notice under section 148.
What is the ground?
On the ground, my lords, that the proceedings have been, the materials on the basis of which the proceedings have been initiated.
Part of the assessment proceeding.
No, my lords, it has never been provided despite our request. They don't provide us, they go ahead and they say, interestingly, very interestingly, they say this is a non-adversarial proceeding. My lords, I fail to understand, my lords, how can an income tax proceeding be a non-adversarial proceedings?
All right, heard Mr. S.K. Acharya and counsel appearing for the petitioner. By means of this writ petition, the petitioner has challenged the order dated 25/3/2023. First under section 148, capital A within bracket small d of the IT Act. Annexure 5 to the writ petition. And also the consequential notice that has been issued under section 140. Notice dated 25/3/2023 under section 148 of the IPA and access 6 to the petition. According to Mr. Acharya and counsel, the materials those who are considered were never supplied to the SSC, and even on his request, the supply of the materials or the scope of inspection had been denied. So issue notice returnable on 22nd July. 21st July 2023. Who is appearing for the income tax? None.
Mr. Mahapatra was there.
Can someone call for Mr. Mahapatra? Is he been nearby court?
I just called him, but he didn't answer.
Mr. Mahapatra is not available now.
He's there. He was just there.
Otherwise,
perhaps.
you have to take steps to avoid that. I just request send one of your associates to just call him for 1 minute to this call.
Very well.
In I. Heard such and such. Also record the name of Mr. Mahapatra. SS Mahapatra. Senior Standing Counsel IT. This is an application seeking stay of the further proceeding in terms of the order dated 25/3/2023, annexure 5 to the writ petition, and also the notice dated 25/3/2023 issued under section 148 of the IT Act. So we have issued the notice for examining the challenge. So issue notice returnable on the same date. Since Mr. Mahapatra and Senior Standing Counsel has appeared and appears in his notice for the revenue, no formal notice is called for. The revenue may file the objection, if any, by the returnable date. Release the matter on the same date, 21st of July 2023. Meanwhile, the proceeding in terms of the annexure 5 and 6 shall remain suspended. An urgent certified copy be supplied as per rule. We have suspended the further proceeding.
Please, please.
But I'm waiting for Mr. Mahapatra, whether he has been assigned with this case.
Yes, yes, yes. He was just there. He in item 2 itself, he's there, and I have also served copies.
Already this, Mr. The always made, this made repetition also, Mr. S.S. Mahapatra. Then as Senior Standing Council IT appears in his notice for the revenue opposite parties. How many opposite party? One or two?
Two, my lords.
One additional copy of.
One is the assessing officer, the two is the
So
sanctioning.
one additional copy you just
One
furnished.
additional.
One additional copy of the repetition be furnished to Mr. Mahapatra and Council by tomorrow. All right.
Lordship is keeping it for
21st of July.
very well. Very good. Grateful.
Item 14.
Same, my lords, different.
Order is different.
Assessment year is 1920. The same.
We have not reflected the assessment year there also. We're giving the date.
Date,
Here-
my lords, is 24th. Instead of 25th, it is 24th March.
All right. Same, no, this is 24th of March. Annexure 6 and 7, not earlier also 6 and 7? or
No, earlier it was 5
five
and
6?
6.
6 and 7. Just you see this page 16 and get the materials there. Okay, same order. Mr. Mahapatra has been assigned with?
Yes, yes.
All right. Next.
Item 16.
16 milots, again challenging 148A-D and 148. Milots on the basis of mere change of opinion, no new materials, no new materials. In fact, the
Yes, this
notice.
you take down. Heard Mr. S.K. Acharya and council. The council appearing for the petitioner by means of this writ petition. The order dated 24/4/2023, passed under section 148A, then make a small d. Annexure 11 to the writ petition. And the consequential notice under section 1 dated 24/4/2023 under section 148 of the IT Act, annexure 12 to the writ petitions have been challenged. And Mr. Acharya and council has stated that no new materials have been considered, and as such the proceeding itself is unsustainable. Issue notice, same way, na? Same day,
Very well.
21, Mr. S.S. Mahapatra.
21st.
All right. Interim order the same way. Same way we are issuing notice until then, till the next date, there shall be nothing of that sort.
Annexure.
Interim order. The I 7404. Same way, now we have taken, and this will be no further proceeding till the next date. Yes.
Annexure
Item
11
20.
and 12. Annexure 11 and 12.
11 and 12, we already noted.
I'm great.
Item 20.
Yes, Mr.
This is application
Naik.
nature of habeas corpus, my lord. Last occasion, your lordship called.
Which is the application that you have filed?
Pardon?
What is the application?
Application for restoration, my lord. The writ petition was dismissed for
No. What is the application number? 31848.
the case number 333330 of 2017. my lord.
No, this is the writ petition. What is your miscellaneous application for restoration?
That is, my lord, CMAPL, my lord.
Which is the case number? Because there are two. One is the miscellaneous case, and the IA.
My lord.
Both are for different purpose.
My lord. CMAPL PL is for restoration, my lord. I'm sorry.
There is no such. This is find out in the physical record was there is an application.
That is CMPL number 127 of 2021, my lord. That's for the noting, my lord. The top.
Is there any application on the record? It is there. Why they are not scanning the records? Oh, but it should be part of this record. This has been recorded, submitted already.
Noting it is there, my lord. 127 of 2021.
Okay. No, this is a new application according to the. No order has been passed in this application.
Pardon, my lord?
No order has been passed in this application.
No, CMPL is for, it is for the first time before, my lord.
First time it was filed on 2nd of July 2021.
Right.
So you have entered newly in this case.
My lord.
After death of the previous counsel. Okay. But Mr. Manoj Chand, counsel appearing for the applicant. There is an application for setting aside the order dated 31/3/2021. By which the writ petition being WPC number 330/2017 was dismissed for non-prosecution. Issue notice returnable on 7th of July. 7th of July, steps for service of notice on the sole opposite party shall be taken by 19th of May 2023 by registered post with AD. All right.
Only one thing, may I pray, my lord? Since my lord is an institution, and my lord, the entirety of the case, my lord, now the civil court is, my lord, proceeding for taking coercive action. My lord may indicate only for till appearance, no coercive action against the institution, because it is institution.
That without restoring this.
No,
kind of
only my lord, bear me for a
we
moment.
can prepone the
of
date. Prepone the date you file. That has been
No,
taken.
I will, my lord may say, in course of the I will file. In course of the I will file, but I am not on that. Only my prayer. My lord, the petitioner in the application has twofold prayer. First, to implement the order.
You know how to take the time from the court. So we are preponing the date of return. It will be 23rd of June. All right. Just immediately after the vacation. You take step by 19th.
22.
So what more do you want to say?
12:30, my lord. 12:30.
12:30?
This matter also same, your lord.
All right, call 12:30.
Do it.
Well,
26.
Mahabharata and Senior Standing Council IT appears for the revenue on advance notice.
Well,
We have not passed any other order. On 23rd, we'll consider.
yes,
it.
yes.
only I pray for there is an attachment now in the meantime.
No, my lord, that has already been effected.
No, attachment not been affected. Affected, then it's become infructuous. Annex 8 is the attachment bills. So till next date bills, attachment may not be given effect. Otherwise, the entire rate will be infructuous.
My lord, regarding demand of 20% against the stay of appeal, my lord, during pendency of the appeal. My lord says that is the statutory provision. My lord,
No,
for
no.
depositing the
If your lordship will see my lord page 55, the only ground that has been taken in the order passed by my lord the authority below saying that because of the severity office memorandum
Give the file.
in July 17, kindly see for a moment page 55. That's the only ground they have taken. And that has been taken care of by Honorable Apex Court. Your lordship have also dealt in with that. Because see, Miller's administrative circular,
Just,
which is not binding, Miller's.
No, that
That's
has
not
been
binding.
given, my lord, that has been by the Honorable Apex Court, it has been held. My lord, it is open for the department to consider,
That has not
to
been
consider,
considered.
my lord,
That
to
has not been
consider.
considered.
In the meantime, during pendency of this case, lordship may direct to reconsider that case, his
Let
application
my
for.
friend file a short reply,
Yes.
take notice, Miller's.
All
Till
right,
next
one
date
thing
only,
that,
Miller's.
in the meanwhile, no coercive action, till the next date, no coercive action shall be taken up. Just till next date, if the 23rd will fix. It is not an interim order.
As your lordship
It is made
pleases.
absolutely clear as we could not take up the matter for consideration. This order has been passed, which will
But
be reviewed
it
on the next
It
day.
will be, my lord, without depositing, obtaining stay, my lord.
We are specifying that it
We
has
are
been
reviewing this
passed.
order on the next date. Our own, we are reviewing the
Obliged,
next order on the next day.
Obliged.
Deeply obliged, my lord.
Unless that granted matter, that was on my legs from another court. I thought I have everything ready, but my file is not with me.
23rd, we have fixed the matter.
23rd.
It is fixed by my lord on
27.
27.
27th.
27th.
My lord.
The next matter.
Item
3.
Item 2.
Three. Item 3.
All item 3.
Item 3.
June 2023.
It will be listed for fresh admission.
Uh,
For fresh admission,
stop.
not further orders.
That's all. Judgments are not listed.
Additionally, motor vehicle matters, your lordship directed fixed today, my lords, on 15.
30 item is there, my lord. Your lordship, batch of cases is here.
Oh, that we fix the date because the matter, because it cannot be taken up.
27.
27.
That connected.
Already we have fixed a date on 27th.
My lord,
June.
27th
June.
June. My lord, interim order, my lord, that time.
No, nothing would happen. Come on 27th. Because today we have no time because after one we cannot sit because of the bar's request.
My lord.
So it come on immediately after vacation.
20
We have heard
My lord.
yes, yes, your
in some of
lordship,
the matters and all.
My lord, so matter.
all it. So we will take our 27, we'll try to dispose of in the court only.
All.
All right.
Your lordship. They 30, item 30 also same, 30 June.
Item 30.
32 days list, my lord. Same matter, my lord. 30.
25, no?
25.
25, that is 25.
25.
Oh, 25 is 30th June.
30th June, my
All right.
Now, all these matters are 27th, my lords. All other batch matters
lord.
27th.
June.
27th.
Oh,
yes.
judgment.
Huh?
On List, अच्छा अच्छा. हो. हे judgment list आहे. हो.
For judgment item 1,
We have made our observation. And we have dismissed our appeal.
So have we?
We have directed the appellant to this, we have to enhance. We are earlier 30 days to surrender before the court. It will be made a 45 days because of the summer vacation and transmission of it, 45 days. In the event of failure, the additional session just shall issue the non-bailable warrant for enforcing the appellant to suffer the rest of the service. Okay. It just next item,
item 2, GSLA 119.
119.
119.
You got another copy.
No, this is not this. This is on the main. We have set aside the imputed judgment and order dated 30/4/2023 with certain observation.
The conviction has been converted to 324.
Oh, yes, conviction is converted to 324.
Conviction is converted to 324 because the main accused is absconding. He escaped from jail.
And the rigorous imprisonment for the 3 years, and we believe he has already suffered these 3 years, he will be released. We have not observed anything, we'll send the judgment to the court.
And period undergone.
3 years, so
3
must
years,
have undergone.
undergone already, that we do not know.
Item 3,
I'll check if he's on bail, then bail 1 will be cancelled. I'll check the record.
No, if it is already 3 years undergone, we'll discharge the, she will respond to the obligation.
If he's on
Yes.
bail after undergoing that.
Yes.
I'll check from the LCR.
We have set aside the judgment and order of conviction and sentence. On benefit of doubt, the appellant will be released forthwith.
item 4,
कौन पट्टी ना नाश्ता बोले
Ms. Patnaik, there is a very, very sorry incident in the jail. We have directed the state government to pay the compensations to the extent of 25 lakhs to the family of the deceased. You will get the copy after 5-6 days.
item 5,
Yes.
In view of the above discussion, we have the view that the impugn order dated 26/12/2016 passed in CP number 24 of 2015 passed by the learned judge, family court, Baleswar is liable for interference. It is accordingly set aside.
All right. All matters are over.
Happy vacation to your lordships.